Okay. Are we ready to go?
Welcome to Ultimate Investor.
Thank you. Thanks for inviting me along today, Balta.
Mike, a round of applause, please.
It's all a little bit nerve-wracking seeing all these faces, but yes. So yeah, my name is Mike Heiner. I run a business called Strategic Asset Protection. So we work with clients that want to more fully protect and preserve their assets and their wealth for future generations, ultimately. So we've had a lot of conversation, obviously, today about building your wealth and such like, and how you're doing that and such like. So my role really is, what happens, dare I say it, at the back end. What happens to that wealth that you've actually created when you ultimately pass away? So we're going to look at things today. We're going to look at wills and trusts and bits and pieces and some strategy stuff as well. So little agenda. So we're going to talk about a little bit of an introduction to me and strategic asset protection. We're going to talk about the rules of intestate, which is about, if you pass away without actually making a will, what actually happens to your assets at that point, who actually benefits from that point. We're going to talk about simple basic wills and the issues potentially with simple basic wills that people set up, which is what most people tend to do. We're also going to look at the threats to your wealth if you do just only have simple basic wills in place. We're going to look at a bit of property ownership. So how you own your properties is really, really important as well from an estate planning point of view. We're going to then start looking at our asset protection strategy, so what we do with our clients in order to protect and preserve those assets going forward. And then we're going to look at some simple strategies really about rental income. So if you've got property in your own names and you're renting those properties out, about income. What's the best way to own those properties? Well, the best way to own those properties so that you're getting the best income out of it, not paying too much away to the tax man. We're going to look about gifting a buy-to-let property as well. If you've got it in your own name, gifting buy-to-let properties to family members, sons, daughters, that sort of thing, what can be done. And then we're going to look a little bit about capital gains, just really briefly over capital gains. And we're going to talk about inheritance tax and some of the mitigation things as well that you can do to reduce down your inheritance tax liability when you ultimately pass away. And we're also finally then just going to look at a simple little investment kind of thing that you can do that, again, it's called BPR qualifying investments, where we can reduce down inheritance tax over a slightly shorter period. So, this is me, Mike, Strategic Asset Protection. So I started in 2000. Before 2000, you might not think it now with the way that I am, but I used to be a professional tennis player. So started in doing professional tennis, as it were, and then got to an age, got married and that sort of thing, decided I probably need to get a proper job. So I went into mortgages and protection and investments and all that sort of stuff. So I did the whole corporate thing. So I went through Barclays and Halifax and so on, putting together, doing, the mortgages and the protection and bits and pieces. So I had the bright idea in 2007, just before the crash, to leave my security of the corporates and set up my own business doing mortgages and protection. Obviously just before the crash, but luckily we survived that and it was pretty successful. And then in around 2012, I was looking for an additional service to add to the business, really as a way of generating leads for that mortgage and protection business. And wills was I'd always been intrigued by wills because my mum was disinherited and it was all that, the reasons as to why was always, was intrigued by that. So in 2012, I did all my courses and such like, started to learn about it all, and we started to introduce wills as a lead generation tool. So we started to write wills for our clients. And then in 2018, it became very apparent to me that there's a lot of people out there that are doing financial advice and mortgages and all that sort of stuff, but nobody was really focusing on this stuff, the asset protection stuff, the wills and all the rest of it, to a standard. So you had a lot of will writers out there that were just, 250 quid, see you later, here's a will, see you later, never to be seen again sort of thing. But that really wasn't what I was really interested in. I was really interested in building frameworks for my clients to ensure that everything was fully protected and preserved at the point when they ultimately passed away. So that's when, obviously, Strategic Asset Protection was born. I gave up my regulation at that point in 2018, and we focus purely on doing strategies for clients full time. And that's where we are now today, going from strength to strength. Some of you may well have also seen me, I don't know, on TikTok. I've got a large following on TikTok. I know it sounds really bad, but but yes, I've got nearly 45,000 followers on TikTok now, and probably 98% of my business comes from TikTok. So we started TikTok doing kind of, really as an educational thing, really more than anything else, trying to kind of educate people about asset protection and wills and trusts and power of attorney strategies and all that sort of stuff. So I do little 3-minute videos on there, been on there for about a year now. So tons and tons of information. If you want to follow me on there, tons and tons of information about just little snippets of information about certain aspects of planning. Yeah, so feel free to join me. So when it comes to estate planning, there are 2 distinct elements to estate planning. The first element is what we call death planning. Okay, death planning is exactly what it says on the tin. We are planning ultimately for your death. So we're looking at things like wills, we're looking at trusts, solutions obviously, and we're looking at lasting power of attorney. Okay, so that is all under the death planning, which is the majority of this presentation is going to be based around the death planning and what we can do with assets that you've got in your own estate, as it were, to get those assets fully protected for the next line of beneficiaries. You've then got lifetime planning, which is inheritance tax solutions, gifting solutions. We've got business and agricultural relief, potentially, if you've got those kind of assets. And we've got business qualifying investments as well. But like I say, the first part of it is the death planning, and it's the bit that we always do first as well. Okay, so it may well be that you've got yourself an inheritance tax liability, but we need to always sort out the death planning first, because we never know when that's going to happen. So we always do the death planning first, and then we would come back and start talking about lifetime strategies, inheritance solutions, that sort of thing. So, can I just grab a show of hands? Who's actually got a will here? All right, okay. A fair few. And of that, has anyone got a trust? Brilliant. A couple. Okay, so it's the majority of normal simple wills. Okay, so here in the UK, if you pass away, die, in other words, if you pass away without a will, you die what we call intestate. Okay, so the intestate rules are a set of rules that are set out by the government to determine who actually benefits from your estate when you ultimately pass away, because you didn't write a will while you were alive. So the government take that responsibility over. So, here we go. So this is a married couple, Mr. and Mrs. Got 2 children. So Mr's going to pass away. You'll find there's a theme with these slides, actually. It's always Mr. that passes away first. But Mr's going to pass away, and ultimately, Mrs., through the rules of intestate, she will receive the first £270,000 of the estate. That is it. And half of any residue. The other half will go immediately now to the children, if they're of an age. So if they're 18, they will benefit. If not, it will be held for them in trust until they become of an age where they can actually benefit. But 270 grand is not a lot, really, and that's up from 250,000. It's only just increased, as it were. So, but that is the rules of intestate if you're a married couple. Okay, wife gets the first 270,000 and half of any residue. The other half will go directly to the kids now. Could cause problems later on. Okay, this is a couple now that have got no children whatsoever. So again, exactly the same thing. He passes away. She receives everything at this point. So if he had an idea that he wanted to leave something to charity or to a friend or some, family members or whatever, that won't actually happen. It'll all just go to her. Gets the whole lot. Okay. So, statistics. 70% of the UK population here in the UK have got no estate planning whatsoever. Nothing. Nothing at all. No planning at all. Which means that 30% actually do have some kind of a will. But does it do what they want it to do? So, let's take a look at a simple, basic will structure. I'm guessing that most of you, if you put your hand up in the end, the ones that said they didn't have a trust, are going to have this kind of structure. Okay, so this is Bill and Vera. They've got 4 kids. They went to a solicitor, and the solicitor suggested to them that they should set their estate up as follows. On first death, absolutely everything to Mrs. And on second death, when she passes away, equally between the kids. That's a simple basic will structure. So everyone to put their hands up to having a will, is that roughly the structure that you've got? Yeah? Okay. Standard simple will. Benefits to that. Okay, the positives, it's cheap. It's a real cheap solution, really, really cheap solution. You can get these for free sometimes. If you go to the bank or whatever, they'll do you a will for free in certain cases. Okay, they're simple to understand because a basic will just says, look, I've got the assets today. When I die, I'm going to give them to you. And that's all it does. It just says, I'm just giving those assets to the next line of beneficiaries. There's no protection over it whatsoever. Negatives can be expensive at the back end when we start losing some of these assets out of the estate. We'll come to that in a bit. Can cause problems for the drafter, i.e. myself, potentially. Getting things wrong with the residence nil rate band and such like. Does anybody know about the residence nil rate band in here, by the way? Ever heard of the residence nil rate band? No? Good job, we're going to cover that as well then. Okay, and it's not the best option, obviously, for married couples or civil partners either. A simple basic will. So what are the threats to having just a simple basic will plan in place? So somebody's passed away, bless him, it's Mr. again. So now what's happened, because all the assets have passed to Mrs., these are the attackable events within her lifetime now. If anything happens, you know, any of these events happen, obviously we're going to start losing some assets. So because she owns everything, if she goes into long-term care now, we're going to lose some assets out of this estate because she owns everything. We gave everything to her, directly to her. If she gets married and then subsequently passes away, you know, remarried this is, obviously, then we're potentially going to lose some assets. And that's, I'm going to show you in a bit, but that's exactly how my mum was disinherited. And I'll show you exactly how. So she gets married again, she goes for a divorce, obviously she's going to lose some assets, bankruptcy, means tested benefit, disability benefits. All could attack the estate if everything's just left to her through a simple basic will. On second death, so now everything's passed on down to the kids, split equally. Again, now we've got the massive one, which is their divorces. So if we've just given those assets to the children, now if they then go through a divorce, potentially we're going to lose 50% of the assets that ultimately, you know, we passed on to them, directly onto them. Great, not great. And again, same with the bankruptcy, long-term care fees, because again, all we're doing is giving those assets to them. We're increasing the size of their estates as well for inheritance tax purposes. Don't really want to be doing it. So, really, really important to understand that a simple basic will holds no protection over the assets whatsoever. It just passes the assets on to the next line of beneficiaries. Really important to understand. So, how assets are actually owned is really, really important. So, I'm guessing you've all got your own main residence, have you? Houses that you live in, you know, with your partner. Now, how do most of you own those properties? Do you own, so the main residence, if you own it with somebody else, do you own it jointly or? Yeah? Okay. So, there's a couple of ways in which you can, well, first of all, you can only bequeath assets that you own, obviously, but there's a couple of ways in which you can own property. Obviously, we've got limited company on here, which is probably what most of you have got your portfolios in and such like, but this is purely about, you know, just individuals, as it were. So you can own it jointly, you can own it tenants in common, or you can own it solely. So, for married couples, so this is exactly how my mum was disinherited. My nan and granddad had a basic simple will. And my nan and granddad, that's them there, as it were, happily happy, but unfortunately, my granddad passed away fairly early. He was only in his mid-60s when he passed away. Problem for my nana was that she got lonely, and then she met Bill, Mr. New. They then got married, but the problem for my mum, because they set up a simple basic will at this point when they got married, the problem for my mum at this point was that my nana died first. And when my nana died, absolutely everything that my granddad had worked so hard to create, that he gave to my nana when he passed away, obviously, all went to Bill. And the problem for my mum was that Bill already had his own daughter as well. So when he died, he changed his will and left everything to his daughter, completely disinheriting my mum from the kind of the heirlooms that ultimately should have come on down to my mum and then on down to my daughters and such like, completely disinherited, which also left then that my granddad worked his entire life and nobody ever benefited. None of his bloodline actually benefited from his hard work at all. Nobody. It all went to somebody that he'd never ever met. And that is the danger of a simple basic will, is that you're just passing those assets on to the next line of beneficiaries. Now, divorce these days, 42% of all marriages will end in divorce. So if you're only setting up a simple basic will and you've got your own kids, because it's not uncommon now when you get divorced that you're taking your children, you're amalgamating kids together, as it were, or families together, that we could be potentially disinheriting those children later if we've got this kind of structure. So, how would we go about doing to make it better? That's another important one, okay? When you own something jointly with somebody, okay, it doesn't matter what you put in your will, okay, you can't leave your half of the property if it's owned jointly to your children or your spouse or whoever it will be. It will always pass to the surviving joint owner. So I got a case probably about a year ago now. I did a case for a couple of friends. I say they were not friends of mine, but they were clients of mine, but they were a couple of mates. And they were doing a bit like you doing. They just started buying property. But they just, not within a limited company or anything, they just started buying property together. 7 they bought in total, and every single one of them was owned jointly. Every single one of them. So when you explain to them, well, actually, you know what, because they all said, oh yeah, well, in my will, it's going to go to, my bit's going to go to, my wife or whatever it was. It's just like, no, that's not actually going to happen. Because you own something jointly, it will automatically pass to the surviving joint owner. So the first thing, obviously, we did with that was change it all to tenants in common, which is what we talk about now. So tenants in common, if you own property with somebody else, this is exactly how you should be owning it, okay? Outside of a limited company, obviously, always limited company, brilliant, but if you own something with somebody else, this is always how you should be owning your properties. So what we've got here, we've got Mr. and Mrs. obviously, we own a house, okay, we would sever the tenancy on this, that's the first thing we would do, so it would be owned tenants in common, which means that we're going to own a defined share each. Now that's 50-50 at the moment as a married couple, but it could be 70-30, 90-10, it can be whatever percentage we want it to be. But in this respect, we're doing 50-50. That's the first thing. Second thing is that we're going to set up a will. Because I physically own 50% of the property, I can will that 50% on to whomever I wish. So I hasn't got to go to my wife, I can will it on to my kids if I wanted to. That's the other thing. So we're going to set up the wills that go with this. And best advice will always be from us is that we set up a trust. Okay, we set up a trust, ideally to hold the individual halves. So what we mean by that is that when Mr. passes away again, bless him, his half of the house will go into trust, fully protected now for his beneficiaries, i.e. his children. Now his wife, at this point, she's left owning just half a house at this point, but she will also be a trustee and a beneficiary of the trust that holds the other half. She'll be first-line beneficiary, which means that she doesn't own that half, she just has use of that half. So she's still got full control of the property, although she only physically owns half. Okay? So, in order for it to be tenants in common, on title at Land Registry, it should have that paragraph. If that paragraph's not there and you own a property with somebody else, then it will be owned jointly. Okay, so we're looking for that paragraph on the title deed. Okay, our asset protection strategy. So what do we do then? What's different about what we do to the normal simple will writers? Well, the first thing we will always do is exactly what we just did there. Okay, we'll look at the properties that you own and how you own those properties, and we will always look to sever the tenancy on them. Always look to sever the tenancy on them. And we're also going to obviously rewrite your wills, and we're also going to set up the trust as well. Okay, because we want to make sure that on first death, that the half is always fully protected in trust. Okay? This can be any other, it doesn't just have to be property, this, by the way. This is all the other assets as well. So savings, investments, shares within a business, whatever it is, will go into that trust on his death. Okay? He passes away, his half goes into trust. So as I said before, she's going to be a first-line trustee, or she's going to be a trustee and a first-line beneficiary of the asset, obviously, that's gone into the trust, so she can fully control the property. But the other benefit to her, here in the UK, 40,000 homes are sold every single year to pay for care. So you end up having to lose the property to pay for your care, but not this way. Half of the property is already in trust, which means now then if she goes into care, the financial assessment team will come round and assess the value of the property, but there's no value to half a house. No value whatsoever to half a house. Nobody wants to buy half a house. So immediately they put a 0 in the box for the value of the property. So that property now has been fully protected from being sold to pay for the care. We can go one step further with that as well and actually put the property itself into trust, but always only the main residence, because there's no capital gains or anything like that to pay on main residence. So we could put that main residence into trust, which is what I did with my mum's property about 3 years ago. When we lost my dad about 5 years ago, my mum moved down closer to where I was. And I didn't want to go on title for the property, obviously, because if I go on title, it then becomes part of my estate for inheritance tax purposes. Don't want that because I've already got an inheritance tax liability myself. But also, because it's not my main residence, it would start accruing a capital gains liability. And again, I didn't really want that either. So then when I sell the property after my mum passes away, I then ended up having to pay 28% in capital gains. Not great. So the only option I had at that point was to put mum's property into trust. So it's owned by a trust, still forms part of mum's estate for inheritance tax purposes, but she ultimately, at Land Registry, it just says that it's actually owned by a trust, not by my mum. That way, when again the care assessment team come round, they can't then make her forcefully sell the property because mum doesn't own the property. It also saves on probate costs as well by putting the property into trust. Because the property itself now, because we put assets into trust during your lifetime, it then doesn't have to go through the probate process. Yeah? So it's still going to go through the probate process with regard to the value, but the physical property itself, I could move in there that afternoon, as it were, and start selling that property, no problems at all. I haven't got to wait for grant of probate because it's in a trust and we are trustees. We can manage that property quite easily. Okay? So that's the first thing that we would do. So, not all married, obviously. Some of you are single, I'm guessing, and you've got property in bits and pieces. Exactly the same thing. Mr's here, he's got his children, his grandson. Again, we would set up, in this case, a discretionary trust of residue, which would hold his estate on passing. Everything would go into that discretionary trust of residue on his passing, okay? May well potentially create periodic charges. Not going to go into all that at the moment because it's just kind of a whistle-stop tour, this just through it sort of thing. But ultimately, the assets would go into his trust when he passes away. So this is husband and wife again, slightly larger estate this time. So husband and wives, you have what they call spousal allowance, okay, which means you've got unlimited gifting allowance between husband and wife. So, because of that, we've got a £2 million estate. We've segregated the estate as much as possible. So we've got £1 million on his side, and we've got £1 million on her side. Bless him, he's going to pass away again, bless him. But when he passes away, now we've set up within the framework here, we've got 2 trusts. He's got 2 trusts in this respect. The first trust is what we call a nil rate band trust. So it will hold up to his lifetime allowance, and also, because of the value of their estate, he qualifies for the new residence nil rate band, which I'll talk about in a little while. But because it qualifies for the residence nil rate band, it's an additional £175,000 of allowance. So ultimately, the 2 of them, as they're married, they have a lifetime allowance of £1 million before their estate pays any inheritance tax at all. So in this respect, we've got a nil rate band trust, which will hold the tax-free element on his death. And then we've also got, so the first 500,000 goes into the nil rate band trust. We've also then got an IIP trust, an interest in possession trust, which they can have because they're married. And this is the bit that deals with the spousal allowance. So any excess is deemed as a gift to the IIP beneficiary, i.e. the spouse, the wife, husband or the wife, depending on who passes first. Spousal exemption applies, obviously, so no inheritance tax to pay. But what we've managed to do at this point is we've managed to protect up the full £1 million into trust, fully protected, ultimately later on for the beneficiaries, the children, whoever it may well be. And then when she passes away, exactly the same thing will happen. The first 500,000 will go into the nil rate band trust. Any residue will go into the IIP trust. So that can be any amount. It makes no difference if the value of the estate is 2 million or 100 million. The framework there will be sufficient to hold that value. Again, it may well trigger some periodic charges later on, but again, don't really want to go too much into that because that's kind of the mechanism of and how the trusts work and all that sort of stuff. But again, that would be a typical framework for a client of ours, or a husband and wife client of ours, that have got an estate valued over the inheritance tax threshold. Okay? If they were under the inheritance tax threshold, all we'd be looking at doing here is just having the nil rate band trust. We wouldn't need the IIP trust. Okay? But it fully protects up the full estate at that point. Okay, managing rental income. So have you got personal buy-to-lets? Anyone got personal buy-to-lets as opposed to, yes, you have. Okay, does anybody own those with somebody else? Yeah? Okay, and do you find that you end up having to pay tax on those properties, or a lot of tax? Yeah? Okay, now a lot of that sometimes is because of the way that it's structured. So if I bought a property with my wife, for instance, the two of us, I'm a high rate taxpayer, my wife's a non-taxpayer. But if we set it up between us, where I own 50% and she owns 50%, really we should be dividing the income 50% to me and 50% to her. And that's the situation we've got here. So we've got Mr., who's a high rate taxpayer, Mrs., who's a non-taxpayer, but because of the way that the property is actually owned and the structure of this, when the rental comes in, 800 quid a month, it's not a very big property, 800 quid a month comes in, 50% is paid to Mr., but he only gets to, £240 is paid to Mr., but he only gets to keep the 160 quid. Yeah, or sorry, he gets to keep the 240, but £160 of it is paid in tax because of the fact he's a 40% taxpayer. And then you've got Mrs. down here who gets to keep her £400 because she's a non-taxpayer. Is anybody familiar with it? You can kind of identify with this? Yeah? So what can we do then to change this structure so that Mrs. gets everything and we can save the tax? Well, what we can do, so there's a £1,920 tax bill with the way that structure is at the moment. But what we can do is we can set up declaration of trust and an equity split. So in other words, we're going to change the equity split between the two. So it's not going to be 50-50 anymore. It's going to be more like 99-1 or 90-10 or whatever it is, so that 90%, or in this case 100% of the income is paid to Mrs., but nothing's paid to Mr. It does include, obviously, you've got to bear in mind that you're going to be giving away that 80 or 90% of the value of the property, as it were, to your partner, as it were, but it does save, ultimately, £1,920 in tax, just by setting up a simple declaration of trust and changing the split. Okay, gifting a buy-to-let property. This is historically extremely difficult to do because the trouble with buy-to-let properties is it sits within your estate, and also when you get rid of it, it immediately triggers a capital gains liability. So what we're going to try to show you doesn't mitigate the capital gains. Okay, but what you can do, because a lot of the time I've got all this asset sitting here in this buy-to-let property, I've got all this cash sitting there, and ideally I'd like some of it out of my estate, but the problem also is that I want to keep the income. I don't want to just gift the property because then I lose the income. So what you can do, here we are, we've got Dad, he's got his buy-to-let property, we've got a son over here, and Dad at the moment is receiving 100% of the rental income. Okay, so what we can do is we can gift an undivided share of the property. Conveyance is required, but now I can give 90% of the value of that property to my son. As long as I retain 10% of it, or a proportion of that property, I can retain 100% of the income. Okay, I can't occupy the property, so this is only buy-to-lets, so I can't occupy it at all. It's a gift, obviously, it's a potential gift with pet, potentially exempt transfer or a chargeable lifetime, depending on how you gift that half, whether you gift it via a trust or whether you gift it directly to him. Capital gains obviously would be paid on the disposal of the 90%. That's the other thing to bear in mind here. So we're going to pay the potentially 28%, But then after 7 years, as long as he survives for 7 years, the dad at this point, after 7 years, that 90% value will be fully outside of his estate for inheritance tax purposes. And he will have also retained 100% of the income throughout that period as well. Okay? Okay, getting there now. Capital gains. I'm guessing you all know about capital gains, yeah? You know about the limits all being reduced down. So, what do we pay it on? Okay, most personal possessions worth £6,000 or more, apart from your car. Okay, you're going to pay capital gains on, potentially if you sell it. Property that isn't your main residence. Okay, as long as it's not your main residence, again, when you sell it, obviously, there's potentially capital gains to pay. Your main residence, you will pay capital gains on your main residence, though, if you've let it out previously for a period of time, or you use it for business purposes. You potentially would pay capital gains. Shares that aren't in, obviously, an ISA or a PEP. PEPs aren't around anymore, but yep, PEPs. And business assets, you're going to pay capital gains on. These are known as chargeable assets, okay? So any assets that you've got within there, as it were, and you sell them, as it were, having made a bit of a profit, you're going to pay some capital gains on. Okay, not a lot of people know this, but when you pass away, if you've got a buy-to-let property, for instance, okay, with a capital gains liability on it, when you die, that capital gains liability dies with you, okay? That's really important to understand. A lot of people don't know that. People think, well, I'm going to pay the capital gains on it, and I'm also going to pay the inheritance tax. But it's not. You're only going to pay the inheritance tax if the inheritance tax is due. Capital gains liability will die with you. Okay, so there are ways in which you can gift potential buy-to-let properties out by refinancing those properties, taking the cash out and gifting the cash to your beneficiaries now, keeping the property, obviously, and then when you pass away, the property is then passed on to your children, capital gains tax-free. But they've had the cash during your lifetime, you've survived for the 7 years, so it's outside of your estate, and then on your passing, they then receive the property as well. It's one thing. Capital gains is payable on UK, is payable by UK, because this is domiciled now. Is there anybody who's non-domiciled? You all UK domiciled, non-dom, yeah? A couple of non-doms. Okay, so if you're UK domiciled, it means that you end up paying tax on your worldwide assets, regardless of where they are in the world. Your worldwide assets you'll pay capital gains tax on if you dispose of those assets. A new one that's just been brought in, as it were, you also pay capital gains for non-doms now, as it were, that own residential property here in the UK. You're going to pay some capital gains on those properties as well, main residence properties. The allowance has just changed. I'm guessing you all probably know that as well. It's gone down. It's £6,000. That's it. Now, that's the allowance that you've got. It's nothing. Absolutely nothing. So if you're making a fair bit, then you've only got £6,000 in which obviously you can use to mitigate that bill. If it's in a trust, it's only £3,000. So, yeah, there's not much there anymore. Okay, high rate taxpayers. If you're a high rate taxpayer on property, if you sell that property and you pay the capital gains, you're going to pay it at 28%. On any other assets that you've got, you're going to pay 20% for high net worth clients, yeah, high rate taxpayers. Basic tax rate payers, you're going to pay 18% on the gains on residential property. Anything else, you're going to pay 10%. It's quite a lot, really. 28% on a buy-to-let is a lot. Okay, inheritance tax, the big one. Everybody in here, if you've got assets here in the UK, you have a lifetime allowance of 325,000. That is it, 325,000. Okay, as a married couple, obviously it doubles up. You've got 650,000 as a married couple. That is now frozen until April 2028. So it's going to stay at 325,000. So, residence nil rate ban. So I'm surprised that nobody knows about the residence nil rate ban. No? Residence nil rate ban was introduced April 2017. What it is an additional inheritance tax allowance for the fact that you own a residential home. Okay, it was phased in over 5 years. It's now currently sitting at its final position of 175,000. So this is where we talked earlier on about the fact that you have a lifetime allowance as a married couple of £1 million, because you have your 325,000 and you also have the residence nil rate band of 175,000 if you have a residential home. But we'll come to that in a sec. So both of those are frozen so it's frozen at 175,000 until 2028. And the residence nil rate band, I'll say, is currently 175,000. Qualifying criteria. Like anything that the government introduces, there's always a criteria for it. Do you qualify? Do you not qualify? So, you must first of all own a residential home that you live in. That's number one, regardless of the value. Well, at this point. Residential home that you must live in. That's the first part. You must also have children. If you don't have children, you don't qualify. You must have lineal descendants, children that you are going to be leaving that property ultimately to. The estate, the total estate, not the value of the property, but the total estate must not exceed £2 million, because the residence nil rate band will taper away at £1 for every £2 that you're over that £2 million mark. So as a married couple, you'd be losing at 2.35 million, the residence nil rate band would be gone completely, and you'd be back to your 325,000 each. That's it. Okay? This is where they're making most of their money. There we go, 2.35 million. Mitigating inheritance tax. So what can we do? We realise we've got an inheritance tax liability. So this now is going on now to the lifetime planning element. Okay, this is stuff that you do during your lifetime. The death planning stuff happens when you ultimately pass away. So if you've got an inheritance tax liability, the death planning is not going to mitigate that. The only bit that's going to mitigate your inheritance tax liability is doing something about it while you're still alive. That's why we have the two distinct areas. When you die, if you've got a sizable estate, the framework that we would set up would be sufficient to hold whatever is in the estate at the point of you passing, but it doesn't mitigate the inheritance tax. We've got to do that during your lifetime. So, some simple ones. Gifting solutions. Direct gifts. Give it away. Give it to the kids. There it goes. £1 million. There you go, son. There's £1 million. There's dangers with that, obviously. First of all, I've got to survive for 7 years. If I survive for the 7 years, well, that's great. It's outside of my estate at that point. The problem is, as in going back to the slides we talked about before, is that £1 million now sits in the estate of my son. So I've immediately created my son an inheritance tax liability by giving him £1 million. The other problem I'm going to have, and the real problem I'm going to have, if my son then goes and gets married and then gets divorced, £500,000 is going to go walking off down the road that I worked so hard to create, not my son, because I gave it to him. I worked so hard for it, it's going to walk off down the road now and feather a nest of people that I've never ever met. I'm not happy about that. So but that's one option you have got, is just to make those gifts. The other option you got is to gift into trust. But again, there's limits to what you can do with regard to this as well. So when we set up a gift trust for a client, we can only put into that gift trust your lifetime allowance of 325,000. That's all we can put into that in the first 7 years. Okay? And if we put more than 325,000 into that gift trust, we're going to pay 20%, which is an entry fee, so it's half the death rate on the bit above the gift trust. On the bit above the 325, and you're also going to pay potentially a periodic charge every 10 years as well. We don't do that. We only ever put into it up to the 325,000. But you've got to bear in mind, if you're investing that fund in as well, you've also got to factor in growth as well. Yeah. Okay, both these options are potentially exempt transfers or chargeable lifetime transfers, depending on how you do it, which means again that you've got to survive for the 7 years ultimately for it to be outside of your estate. So, ways that we can mitigate. We talked about the gifting. These are other ways that you can do it. Business relief. Certain types of trading businesses qualify for business relief, which means that your share value in those businesses would be outside of your estate for inheritance tax purposes, potentially at 100% relief or 50% relief, depending on what type of business it is and the shares that you own. Exactly the same for agricultural relief. Yeah, so if you own a farm, for instance, a working farm, if you invest in a working farm, as it were, it potentially would be outside of your estate for inheritance tax purposes because it would qualify for 100% relief. You have an annual allowance. Now, I know it doesn't sound much. It's £3,000. It can go back 1 year as well in the first year that you do it. But you can gift £3,000 every single year out of your estate, no 7-year rule at all. Okay? And if you're feeling charitable, you can donate 10% of your estate to charity. And then you get a reduced rate, 6%, what it is, 4%, yeah, 6%. 6% off of the 40%, so you're going to pay 36% as opposed to the 40%. The best one of all, spend it. Have a good time, enjoy it. You've worked hard for it, enjoy it. It's always the best one. So there is one other way that you can, that's the 7-year rule. That's how it works. So it tapers away. So it starts at 40%, and it stays at 40% for the first 3 years, and then it reduces by 8% thereafter. Okay, until after the 7th year when it's completely outside of the estate. Gone. It's in somebody else's estate. Bear in mind though, if you do gift, because obviously it's 7 years, it sits within your estate for that 7 years, and it also sits in your beneficiary's estate from day one. So God forbid you're in a car accident and you both pass away, you're going to end up potentially paying 2 lots. Yeah, so it's something to bear in mind as well there when you make those sort of gifts. Anybody know about any of this? Business qualifying investments? No? Brilliant. Okay, BPR qualifying investments. Open to UK residents, 25 grand minimum investment, £1 million maximum investment. The value of what you invest in is outside of your estate in 2 years. 2 years, not 7 years. Okay, but it's just it's an investment that you can get involved in. You need to seek professional advice on this, so from a financial advisor. But if it's something you're potentially interested in, we can put you put you with the right people for that. So this is just a basic chart, really, of the difference between business property relief investments and also trusts, gifting. So it's exempt, obviously, after 2 years as opposed to the 7 years. You've got control of the fund still as well. That's the other thing. You've still got control of the fund because it's just an investment. I've made an investment, it's in. I can pull that money back out again if I want. You can't do that with a trust, obviously. It's you're losing the control of if you're putting it into, or you're gifting it, or you're putting it into a trust, unless you're a trustee, obviously. But you can't benefit from it again. Suitable for power of attorney. Yeah, it preserves, obviously. The impact of the nil rate band is preserved, so we're not using the nil rate band, obviously. It's preserved. Obviously, when we gift something, we're obviously using that lifetime allowance. And it's not a chargeable lifetime transfer either. So there's food for thought with regard to business relief. It's not for everyone, obviously, but it's an option potentially as a way of mitigating inheritance tax within 2 years as opposed to 7, if you've got the cash to do it. Okay, other services and such like that we provide, we're nearly done now, but obviously what we do as well as a business, power of attorney. I've not touched on power of attorney. Has anybody here actually got a power of attorney? Fantastic, fantastic. For me, my power of attorney is more important to me than all the planning that leaves everything to everybody else. Reason being is that my power of attorney, if I'm using my power of attorney or somebody's using my power of attorney, I'm probably not in great shape. Probably not in great shape. And I want to make sure that it's my family, my loved ones, that are actually making decisions about what actually happens to me. That's what the power of attorney is about. It's about allowing other people, your attorneys, to make decisions about what actually happens to you, about finances, about health and welfare. There's 2, property and finance, health and welfare. You get the 2, you register them with the Office of Public Guardian, and then you've got power of attorney in place, which is exactly what you want. Finishes obviously when you pass away. Obviously, gift trusts on there, business trust, agricultural trust, trusts of land, holdover gift trusts, So anything and everything to do with later life planning is what my business actually deals with. And it's a bespoke service as well, so everyone's different. So we don't actually have a kind of like you come and get a will, as it were, and it's just, well, there's your will, off you go sort of thing. The planning is tailored to your individual needs and the individual assets that you've actually got. So we would sit down and go through everything, potentially put together a recommendation report for you, outlining everything, so you're fully aware of everything. And that is me. go back. I've also got some packs. I only brought my rucksack today because I came up on the train, so I've only got 10. But I've got some packs. If you want to take a pack away or whatever, then just come and see me over there, and I'll give you a pack with all my details in it and some fact sheets and bits and pieces in it as well, my brochure and bits and pieces. I've got a few other bits and pieces as well. So, yeah.
Perfect. Ladies and gentlemen, Mike. Nice job. Welcome. Thank you.
I can relax
Okay,
now.
so we're going to now go for a break.